My name's Chris Peterson. I'm a law professor here at the University of Utah, and I'm just delighted to get to join my colleague here in a moment. I'll just give him an introduction. I also, before I start though, I wanted to say thank you to our events staff here at the College of Law, and also our IT staff for all the work that they've done in helping us organize and put this conference together. Thank you. Thanks. It's a lot of work to put on something like this and facilitate a national conversation, and we just couldn't do it without our professional events staff. And I also want to thank all of the folks at home who are across the country. We have several hundred people who are watching online right now, as well as the people especially who showed up in person to try to facilitate a conference like this. Obviously, there's a lot of wonderful things to do, interesting stuff going on in the country, and a nice fall day here in Salt Lake City. So we're grateful that you showed up. Let me begin by introducing Director Rohit Chopra. Director Chopra was born and raised in Plainfield, New Jersey. No, not true. I got that wrong. But I studied at Harvard and Wharton. I was a consultant at McKinsey. I got that on Wikipedia, so I don't know where that came from. I guess that shows you that it's not
the work on sourcing.
He started in consumer protection at the stand-up team after the financial crisis in helping build the Consumer Financial Protection Bureau, and was later selected by Senator, soon-to-be Senator Elizabeth Warren and Richard Cordray, the first director of the CFPB, to be the first national student lending ombudsman at the CFPB. After the Obama years, he was a fellow at the Consumer Federation of America, and then was nominated to be a Federal Trade Commissioner by President Trump and confirmed by the Senate. After his term at the Federal Trade Commission, he was nominated by President Biden and confirmed by the Senate to be the third director of the Consumer Financial Protection Bureau. I've had the pleasure of working two different jobs with Director Chopra, both in the early Obama years at the CFPB when I was an enforcement lawyer and an advisor to Director Cordray. And then also we overlapped at the Consumer Federation of America as well when I worked on consumer financial services there. It's just a tremendous honor for the University of Utah to have you here and to talk about some of the profound consumer protection issues facing America. If you would all join me in giving a warm round of applause to thank Director Chopra for coming, I'd appreciate that. Thanks for coming.
Of course, and to Professor Peterson and everyone here at the university, thank you so much for putting this together. I really am so glad that people get to study law right now in a time of just extraordinary change, where we have really, I think, closed the chapter of the 40 years from 1980 to 2020, where law has really been weaponized to make the powerful people in our society more powerful, where our courts are weaponized against those who thought they would get equal justice under the law. And now we have a center here at Utah that is actually putting together all of the different ways in which our laws and regulations can make sure that people are treated fairly, not just as consumers, but as people in the workplace, as people who start businesses, and across all of their lives. We use different words for them: patients, employees, consumers. These are all human beings that we want the law to serve rather than to make their lives worse. So I think we're combining antitrust, consumer protection, and even exploring things like healthcare and technology to create, I think, a more coherent vision of what is it that we want the laws in America to do.
Well, that's great. Thank you. I also want to mention too, we're also going to use Slido, this app that we found to be helpful for asking questions, and I'll turn to that in a little bit. But I'm going to take the prerogative to ask some of the questions that are on my mind to start us out. The place that I'd like to start is to talk about what sometimes I know at the CFPB, at least we used to call it tool choice. The CFPB is the youngest federal agency in the pantheon of United States government agencies, and it has Congress in the Dodd-Frank Act gave it a lot of different mechanisms to try to influence public policy as it implements the Consumer Financial Protection Act and all of the other consumer financial services laws. So the CFPB, as you know, obviously, Director, but making sure everybody's following along, has an enforcement mechanism where it can bring law enforcement cases. It also has a supervision mechanism where it can conduct examinations or audits of certain financial institutions. It also has a rulemaking function to adopt regulations. It also can adopt guidance, informal guidance provisions, and it has a consumer response intake portal where consumers can complain online or over the telephone about problems that they're having individually as consumers. There's nobody in the country that's more important in making decisions about which of these different tools that you and the agency can use to try to implement federal consumer financial protection law. And I've often wondered, how is it that you're making those decisions? When you see a problem, an inefficiency in the marketplace, something that's unfair or a deceptive practice, how do you decide which tool you're going to use to address that problem?
Well, I actually think in some ways we don't think of these things as really separate approaches. Everything requires a portfolio of how you use everything. When you are kind of in battle on the battlefield, you don't just use a tank or you don't just use a certain weapon. You don't just coordinate in certain ways. You really think of a full-fledged plan of how are you going to identify serious problems and what do you do to use everything to do it. One of the things that I think has been very important about the origins of the CFPB really actually trace back about 100 years ago, when we find that when very large companies had too much control in our country, we created a set of agencies to also identify what the hell is going on inside of firms and report out what is going on and identify where the harms are. So if you look at really what we have done in terms of, say, junk fees, we have really made sure we're documenting it, showing who is affected by it, use existing law to make sure we're articulating clear guidance, updating rules, bringing lots of enforcement actions, and also examining other firms at the same time. It's also about enlisting all of our states, all of our other regulatory agencies to row in the same direction as us. So I think that as you think about what do you want to do to regulate and to hold accountable, you will always need to be litigation ready. You will always need advanced investigative techniques. But most importantly, you have to know what is going on in the marketplace. And I think that last part is the most important.
Well, following up on that, I've noticed that with each of the different tools that the Bureau has, there's a bit of a stock sort of knee-jerk response that you hear from the financial services industry or from sometimes. I mean, one hesitates to generalize too much. But so, for example, for enforcement, I remember in the Cordray years when I was in the enforcement office, we were bringing a lot of, in some instances, innovative, I thought, enforcement cases. The response was, this is regulation by enforcement. On the other hand, in recent years, I know that your agency has been doing a number of guidance documents, circulars. That's an attempt, I think, to try to tell companies the rules of the road before you have an enforcement action, maybe give them a little bit of a warning. But that's often criticized as, I think, not allowing them to provide sufficient input in the way that a rulemaking would have. On the other hand, with rulemakings, the objection is often, well, this is just over-regulation, and all we need to do is enforce the existing rules. So it's almost like you can't win, and no matter what tool you use. And I wonder, how is it that you sort out the signal from the noise? Like, how do you know when maybe you've gone too far and you actually are going to create a meaningful compliance challenge or a problem in the industry that's not really actually acceptable? Or how do you know whether or not that's just the industry's public relations apparatus ginning up false concern? How do you distinguish the
Yeah, it's a good question. One of the things I'm really motivated by, and I hope all of you who are law students also think about this, lawyers can actually be great stewards of the rule of law. They can be officers of the court. They can also be leeches on the economy. And one of the things that we know is that lawyers often want to optimize on how many hours they can bill. So when I talk to, people in boardrooms, people in C-suites, when we tell them the answers of how we will apply the law, how we plan to supervise and enforce for it, that's fewer lawyers that they need to pay for and that they can focus on their real business. I see that as a big win. Where there are issues, we are always talking to firms to figure out how do you answer the questions the best you can with the laws you have. Some of our laws are very old. They didn't necessarily think about every different permutation, but they thought about values and principles about what we should espouse. So, Chris, I don't really sweat this. I think we do everything. We use every tool. And you're right. I think, when you hear both sides, you say, don't do enforcement, do regulations and guidance only, or don't do regulations and guidance, just do case-by-case enforcement. You really just have to use every tool and be as transparent as possible. And I do think we take a lot of pride that we have been able to answer and form a view on many major questions involving the digital economy and the future that has given firms the ability to at least have some answers on how we might interpret a law rather than having lawyers shake them down for their own hypothesis.
Yeah, that's great. That makes sense. Another question that you are uniquely well positioned to answer is in your role as a federal trade commissioner, you were at an independent regulatory agency that's obviously nominated by the president, but an independent agency. And that was, in a sense, the way the CFPB was originally conceptualized by the Dodd-Frank Act, as an independent bureau within the Federal Reserve System, but with a single director. The Supreme Court then, of course, as you know, and others may in the audience, the Supreme Court overturned that structure on constitutional grounds and made the director, removable at the discretion of the President of the United States, in effect making it, in a sense, no longer an independent agency, I suppose. I'm wondering, how is it, as a practical matter, how has your managerial oversight from President Biden been different at the Federal Trade Commission as opposed to here at the CFPB?
Yeah, I don't. This is a largely academic question. The question is there political interference in investigations and examinations? There has never been even an iota of that. There is never an attempt to reach into specific investigations and otherwise. Now, of course, it's pretty normal for agencies to work together to figure out what is our policy view on things. And frankly, a lot of the problems that we are facing are not going to solve by one narrow agency. It needs an all hands on deck approach We have seen that when it comes to really the rethinking of the long-standing failed approach on antitrust and mergers that has been really organized by President Biden with an all-agency approach. There's been an all-of-government approach for so many agencies to tackle the scourge of junk fees that has creeped across our economy on artificial intelligence and so much more. So I think the way I'm pretty fiercely protective of making sure that there is no undue interference in our investigations, but I don't worry about it because nothing has ever come close to that.
Yeah, that's wonderful. Well, speaking of junk fees, I was really excited to ask you about the rulemaking that you've been pursuing, that you pursued under the CARD Act to deal with the congressional, the CARD Act, the statute limited contingent attorneys fees, credit card fees, such as late fees, to no more than reasonable or proportional limits to the harm that was suffered by the financial institution. But it also gave, at that time, the Federal Reserve Board of Governors the authority to create a safe harbor, is what most lawyers call it, for late fees at a particular level. Your administration has revisited that and proposed a reduced fee safe harbor. I'd like you to just talk with us a little bit about why you chose to focus on that and how it's going and what you see as the prospects for successful implementation of that regulation, given the ongoing litigation, if you're able to talk about it.
Yeah, so I think if you look at modern pricing theory and practice in boardrooms across the country, it's a lot easier to try and make more money by disguising your pricing or making it more difficult to figure out in some other ways, rather than actually creating a better product or service. So we see this in all parts, especially of the digital world, where it's like more tricky to cancel. Everything is now a subscription. And I actually think this way in which many firms have approached pricing has actually really undermined how we want the competitive market to work. So in credit cards, you really do, it's the most common, essentially the most common financial credit product people deal with. And when we did a review of some of these old original rules that were promulgated, we found some massive problems. And one of it was that it looked like penalties were a massive profit engine, which is exactly what Congress didn't want. Congress wanted people to look at the interest rate, look at the material terms, and then be able to decide about that. We have also revisited a number of rules that were originally promulgated by the CFPB or the Fed to fix them. And I hope that my successors will always look back and fix as the world has changed. So we were very, very nervous when we were learning that the big credit card issuers were really engaged in a lot of things that were very problematic. Some of the bait and switch tactics on rewards, some of the ways in which they appear to have been coordinating on pricing and credit reporting practices, some of the extremely sketchy collections that they were engaged in. So this one really stood out to us as something that was extremely problematic. We looked at the data, and we have proposed and finalized a rule to lower it. We think that will make the market much stronger. It will really help a lot of consumers. And behind closed doors, a lot of banks will admit, yeah, this gets out of hand. And the way it often works is they set certain targets for business unit heads. They try and find ways to pump up profits in slower times. And our goal is really to make that price clear up front, and that people can really have a fair market. The credit card market has serious problems. Many people, when they are revolving on credit card loans, meaning carrying a balance from month to month, something is happening in their life. They don't necessarily switch to a low rate card. Many people feel that they're primarily choosing based on rewards. Those rewards cards have huge APRs relative to other ones. But when they start getting in debt, the treadmill gets faster and faster. And we saw, as the Fed was increasing interest rates this last cycle, boy, did the credit card issuers raise rates by way more than that, even when adjusting for other factors. So it's important that we figure out, if people are paying $120 billion in interest and fees, what can we do to kind of wring out those anti-competitive profits? And that's just one of the things we've done. We've tried to approach the fee issues on so many other different financial products, and I think it is already delivering tens of billions of dollars to the country.
Well, one of the challenges that the Bureau is facing is that most of your rulemakings are leading to lawsuits from industry, primarily being filed in Texas and in the Fifth Circuit. And those cases are all going to be filtered through recent Supreme Court precedent that is reshaping, arguably, administrative law in the United States. The Chevron doctrine was a longstanding doctrine that said that where there was ambiguity in a statute that Congress adopted, the administrative agencies typically had authority to adopt a reasonable approach to addressing that ambiguity in their regulatory rulemakings. And also the Corner Post case from last term also said that if there is a old regulation where in a new business that has been affected by that old regulation, the new business could toll the statute of limitations for challenging that regulation, even though the regulation had been long-standing for many, many years. The combination of those two new Supreme Court doctrines seems to me to imply that we could see a lot of new attacks on CFPB regulations. How are you thinking about how to guide the Bureau and continue to have a positive consumer protection regulatory apparatus in our country with the changes that we're seeing in administrative law?
We've been really lucky because the earliest days of the Bureau, the enormous challenges and the swift attacks, in some ways trained the agency early on to just be better. And in many ways, we made a very important decision early on. Our general counsel, he's the first CFPB general counsel who knows consumer financial law and administrative law. And I think stewarded us through a Supreme Court challenge, which we were victorious in, an enormous set of wins in appellate litigation, and really, I think, have been able to navigate the current waters exceptionally well. We have been able to provide a lot of advice to other agencies who are dealing with just an avalanche of this similar type of litigation. But, I don't sweat it too much. In many ways, we recently were victorious in a appellate court review in a matter called Townstone, which was about the Equal Credit Opportunity Act. Our statutes also, a large number of them have express delegations of authority for rulemaking to prevent evasions and others. So I think we're always ready for what's next. I think we've been able to stay 3 steps ahead a lot, and a lot of the credit goes to our general counsel Seth Brotman and his team for just having the agency be ready to navigate all those waters.
That's a great answer. Well, I think I'm being a bit selfish in continuing to ask my questions, and I'm going to turn to just a couple more because I can't resist. As I watched your career, I think that if the things that you've done at the FTC and then at the CFPB, if there's a modus operandi that I've seen you adopt, it's that you seem to look for untapped statutory authorities that have been residing in the U.S. code, waiting for creative new applications of them. The example at the FTC that's most along this lines is the Made in the USA manufacturers across the country, retailers were selling products that claimed to be made in the USA, but only maybe had one small component part made in the USA. The Trade Commission under your leadership adopted a new rule regulation that clarified what you have to do in order to actually have something be made in the USA, and it's an international commerce policy that came into being through the Deceptive Trade Practices Authority. The credit card fee limitation rulemaking that we just talked about a moment ago is an example of something that I think intellectually is kind of similar at the CFPB. So I would propose that if there is a Chopra doctrine, it's finding creative uses of existing statutory authority to do bold new projects. Is that fair?
No. I actually, it's so inherently uncreative to read the statute and use it. So there's nothing interesting about the Made in US. It's an explicit grant of authority to penalize Made in USA fraudsters, but that there was a decision on a bipartisan basis for 20 some years that egregious Made in USA fraud will not be penalized by the Federal Trade Commission. And the Federal Trade Commission is, in many ways, was the poster child of an agency that, starting in the 1980s, had completely run amok. It decided on its own accord that Congress's law, they could veto it, that they actually had veto power over it, and they could say, Congress passed this and wants us to do it, but we're just not going to. And we see it in the antitrust laws, the Robinson-Patman Act, so many others of, we're just going to stop without any real debate about it. So some of it, and it is true, I don't consider it as being innovative. I consider it being faithful to when our legislative branch enacts legislation, do it. And there is nothing creative about reading statutes. And I just want to encourage every single law student here that when you hear that something is impossible or something can't be done, the answer is often in plain sight in those thick books. And I think that that's really more a way of approaching how you steward when you are stewarding the law, you actually have to look at the words on that page, and you don't have the power to just cross it off. That's really what the Constitution spells out, how you repeal laws. Now, of course, there's important questions about prosecutorial discretion, about priorities, about what you will choose to do and when. If you look at much of the rules we have prioritized at the CFPB, it's supposed to be done but didn't do. And we have finished the small business lending rule under Section 1071. We will be soon finishing a long dormant rule under Section 1033. We have engaged in a number of supervisory designations under Section 1024, and the list goes on and on and on and on. We have laws, the Interstate Land Sales Act, that were just sitting there unenforced, and now we're enforcing that. So yeah, I just totally disagree with your characterization on that. And I see it as something about not perceiving that you're powerless, but actually implementing the federal consumer financial laws as directed.
Yesterday, the CFPB announced an enforcement case against an arbitration provider and accused the company of engaging in non-neutral arbitration. It had a financial interest in the cases that it was resolving, and a settlement agreement was announced. Serious potential miscarriage of justice. In addition to maybe whatever insights you have about that particular case, my question is whether or not you think that that case is a one-off example, or if it points to something broader about the widespread use of forced arbitration clauses in boilerplate consumer contracts across America.
Yeah, one of the places that I've studied quite a bit, and I'll encourage those who are interested in contract law and banking law to look at the papers in the 1970s and 1980s of the credit practices rules that were initiated by the Federal Trade Commission in the 70s. And one of the things that they looked at was this myriad of clauses that were extremely problematic. For example, boilerplate contracts that required you to hand over your bedroom furniture or whatever it may be, the goods in your house. The requirement that you automatically plead guilty if there is a dispute, the so-called confessions of judgment. Over time, we have seen the ability for the regulators to prohibit these. It also looks in the Federal Reserve, shows up as what's called Regulation AA. I actually do think there is a whole suite of contract clauses that the CFPB is really looking more closely at. We've issued a lot of guidance about prohibiting people from posting reviews. All of this stuff, we're trying to figure out how do we make sure that there is a fair, transparent, and competitive process. And I think, you ask about forced arbitration. It's just in some ways funny. Creditors across the country are suing people in our state courts like crazy. And so certainly the courts are vindicating the rights for many of them ending up in default judgments. So, you ask about our e-judicate case yesterday. I can't say whether every single arbitral forum is rigged. In this case, it was. But certainly all of the contract language that we click and move on, and that we know is not a salient product feature for where consumers compare, that's obviously a place where we are exercising a lot of thinking on all sorts of contract clauses.
Well, one last question for me before I open it up to folks on the Slido app. I just wanted to add, a lot of our students are here today, and your career has been really meteoric. I mean, I'm wondering if you can give my students career advice. How is it that you've been so successful? What can they take from your life experience as they find their own paths in the legal profession?
Well, one, I should admit to them, I'm not a lawyer. And I think that having lawyers actually not just stay cocooned with other lawyers is probably one of the best ways that you can develop a broader apparatus and worldview about what you want to do. One of the things that's such a huge advantage of the CFPB, we have a technologist. We've appointed a chief technologist who is kind of getting our agency more and more expertise on how to handle the law when it comes to technologies of the future, with people who understand finance and accounting, with people with different types of backgrounds. I think finding where you have the ability to work with others, and not just as clients, but as teammates, is probably one of the best ways that you can navigate your career through different turns. I'd also say that try your best to avoid the herd. You can pretty much count, I went to business school, wherever a huge number of your classmates are going in business school is probably the next industry that will have a crisis or, a huge problem. So try and think about how do you chart that course. And part of what I would really urge you to do is find the faculty members who will help you navigate that. I was very lucky to have a couple of professors who, just wanted to introduce me to people, help me find people, and, just take advantage of every human being who you think sort of is someone who can help you steward through that. I'd also say, Chris, is just like a big picture level. Really ask yourself, why did you study the law? Did you study it because you believe in the law as a way to make society prosperous, fair, and the ideals we want? Or are you doing it to make boatloads of money? And that might be a little bit of it's either answer is fine, but identifying what that answer is early can really help you.
All right. Well, just picking a couple of questions from folks in the audience. A number of people have voted up the question, what are the most consequential pieces of legislation that have gone under enforced that you are seeking to better enforce now?
What a great question. Most of them are, I would say, can it be any laws or just our laws?
Well,
I'll take it how I want.
I think you're the director of the CFPB, so
Here's the ones I think about quite a bit. We have a set of statutes throughout our history. The Packers and Stockyards Act of 1921, the Communications Act of 1934, obviously the Federal Trade Commission Act, Consumer Financial Protection Act, the list goes on. They all outline prohibitions on a set of conduct. In the Packers and Stockyards Act, which mostly protects against abuses of big meat packers and other producers, it bans unfair, deceptive, and unjustly discriminatory behavior. Federal Trade Commission Act, unfair methods of competition, unfair or deceptive acts or practices. The CFPB, also a prohibition on abusive acts or practices. The Communications Act also uses similar words. We also need to figure out, if we want a market-based system, how do we make sure that we have a coherent view about, and to me the question is pretty similar, how do you prevent actors from exploiting their power? It's all about leveling playing field and the asymmetries of power. So whether it's a very big meat packer, a very big telecom company, a big railroad, that is really what we have to stop. And that's why I think this Utah project is in some ways trying to increase the ambit of the types of laws we think about to create that fundamental to fight against the fundamental asymmetry of power that is inherent in so many markets, and for which could position the U.S. to really drive an enormous amount of progress in the world. I would argue that there would be no Google or Facebook had there not been the landmark antitrust litigation against Microsoft. I would argue that some of the major development of the West would not have happened without some of the common sense things we find in those statutes that govern railroads and power utilities and banks and agriculture. So, that history, I think, is very important. And it's not that it's necessarily under enforced, but it easily became captured by a very narrow and cramped view, which the authors of that statute, it's just totally out of sync with.
So Utah, as you know, has about 10, almost a dozen banks that are a partner with fintech companies in a bank partner lending model. One of the members of the audience asks, what's the CFPB's current view on bank partner lending models? Are there any developments on the horizon that could impact those partnerships and fintechs directly?
So I would say we don't think in that kind of framework. Most of our supervision, for example, is already in the non-bank space. We try and look at products and activities rather than corporate form. That being said, I do think you see serious consumer harm with some of these arrangements that are built on regulatory arbitrage. And regulatory arbitrage is not real innovation. It's really just kind of lawyers lawyering. And so I have had really grave concerns about the failure of Synapse. Some of you may know this, that connected to fintech apps and people just were without their funds for so long. They thought they were in an FDIC insured account. They can't get their money. We certainly see this with all sorts of rent-to-bank type models. And that is obviously an important area of focus in how we work with the OCC, the FDIC, and the Fed, as well as others to avoid that. I will share that a major emphasis for the CFPB is actually preparing for the incursion of big tech companies into consumer finance. We have done a lot on this and are being pretty clear that you have to follow the same set of laws. You don't get special immunity clauses. And I will tell you, Chris, that it does feel that many of those fintech or other tech companies purposely market as wanting to be different than banks, but then all of a sudden seem to want all of the benefits of being a bank without the corresponding obligations. But of course, I would say the competition from non-banks, has been important in consumer finance.
Could you speak to the work that the federal government is doing in regards to rental housing as a consumer product? It's something that's not squarely teed up within the CFPB's authorities, but there are probably some opportunities.
Well, I mean, there's a lot in rental housing that we do have to deal with. Certainly, when you go rent an apartment, you are more than not interacting behind, or you don't know it, but behind the scenes, there is an algorithm or artificial intelligence that is a tenant screener that is querying lots of different data about you to determine whether you're a suitable renter. That is, of course, covered by the Fair Credit Reporting Act. There's lots of other parts of it that are also covered by our laws. But I would say if you're asking big picture about what is being done on rental housing, I would, rather than going down the long list, I think there is a sense that the ways in which many residential leases are being structured are ones where you can induce much higher rent as a landlord than we have typically seen. One great example of this is these big move-out fees. So you might get a rent increase notice and say, okay, maybe I should move. I don't want to take this rent increase. But when you need to front $500 plus have a strange security deposit lending arrangement, plus all sorts of other things, you end up accepting the rent increase. You end up seeing that the amount of sort of weird fees that are being charged where people have to pay their rent through a platform. These are just other junk fees that are driving up the cost of rent. There's obviously a much longer set of things that we are all thinking about when it comes to rental housing. But the role of big investors and especially private equity firms in purchasing so much rental housing, there's a lot of evidence that this is creating, in some ways, artificial scarcity and higher rents.
Well, I've kept everybody. I'm going to ask one last question, and then we probably should wrap it up. But and it's a good question. We have a panel coming up on artificial intelligence and consumer finance. But I'm curious, and I think this is a good one. As this technology is advancing, How is the Bureau planning to balance the efficiency benefits of artificial intelligence with the need for transparency and strong consumer protections associated with the use of artificial intelligence in, consumer interfacing, underwriting, and also the potential for artificial intelligence in all sorts of scams and consumer fraud? How are you thinking about all that?
So what I'd say is this, artificial intelligence at its core is not really new in consumer finance. If you think about it, a FICO score is a kind of hidden algorithm that is making decisions about whether or not you get a loan. There has always been algorithms behind the scenes making decisions. There's obviously things that are different right now. And so where we've looked at it is making clear how the current laws on the books, and there may be new laws or amendments, but how they currently apply. And a couple of the examples are, one, if you are using it to underwrite, that doesn't exempt you from federal law that requires you that when you deny someone a credit product, to explain your reasons why. And if you can't understand what your AI is deciding, you can't comply with that then. And I think that that's really just like a basic guardrail. I would say we've focused quite a bit on generative AI, the use of content to interact with consumers. Our chief technologist, Erie Meyer, led a study on the use of chatbots by banks. And what we found is that many of them are simulating human-like interactions. So, for example, Bank of America calls their AI chatbot Erica. They usually are given traditionally female names, and they use certain techniques to make the user feel that it is not a robot. So for example, you may be familiar with the ellipsis you see when someone is chatting or typing to you as they construct their thought. Bank of America's Erica is not like typing and then rethinking. It is just a way to create kind of anthropomorphism. In other words, to simulate a different experience. And what we're saying to that is you can do that, but if Erica is wrong and giving you wrong information, they're responsible for that. They're responsible for it just like they would be responsible for a customer service agent. Obviously, the ability to clone biometrics, voices, faces, and others is going to create a huge amount of problematic scams. I think we have are working on many different vectors of how we can make sure that doesn't occur. But there are a lot of big ticket items. I'm not sure we sort of think about it in terms of a pure trade-off. We have statutes and we have regulations, and we try and answer how they are used. I will say though that we really do believe we are techno-optimists at the CFPB. We want technology to be used for good and not for exploitation and scams. So we're constantly trying to think about that. And one of the things we did is we want to make sure there's lots of different players who are creating things following existing law, but not that we're picking winners and losers. I think the CFPB, before I was director, was obsessed with choosing a particular market winner and crowning them. And they use this process called a no action letter. We're going to give you immunity. And what would happen is that gave that a competitive advantage with very little innovation in the market broadly. So we're just taking a much different approach to make sure that we are able to give genuine innovators who don't want to build a business on regulatory arbitrage how we see the existing laws and rules affecting how they develop. Now, do I think there need to be some changes in law? Yes. I have huge worries about how intellectual property is treated in all this, how our personal data is being used or misused or abused, how we ultimately kind of navigate the issues of criminal liability in some of this. Some of our statutes require scienter. And how do we make sure that reckless artificial intelligence actually has some degrees of accountability? All of that is places where maybe we do need to make tweaks to the law, but our philosophy is let 1,000 flowers bloom, but not ones that are just building a business on fraud and arbitrage.
Well, Director, I have a million more questions I could ask, and I know there are many people in the audience and listening from around the country that didn't get their questions asked, but you do have a plane to catch, and you've been very generous with your time, and we're extremely grateful that you were willing to share some of your thoughts and insights about the future of consumer financial services.
I thank you so much, and I hope as you all are joining this together to think about not just how it really is affecting people in with their banking and financial lives, but what does it really mean to be someone living in our society and economy today? The words consumer protection, it doesn't really nail it. It's making sure that people are able to have some degree of leverage and power in all parts of their life, that they are not mistreated or exploited. And how do we just read the plain text of some of our laws to make sure that we can achieve those goals? So really, thank you, Chris, thank you, Hal, and everyone who's put this together.
Thanks, everyone.